On November 6, 2018, Virginians go to the polls to elect or re-elect their representatives in Washington, but before you vote for Congressman Don Beyer and Senator Tim Kaine, you need to know what they really believe about abortion, what they really believe about intolerance, what they really believe about religious freedom, and what they really believe about preserving and protecting the Constitution, the American way, and our way of life. The events that we are about to describe were presented to both Congressman Beyer and Senator Kaine weeks ago, but they have yet to issue any reply. Perhaps they were more concerned about the upcoming elections. We cannot say. We will not judge. On December 2, 2017, Major Mike Webb was arrested at an abortion mill, the Alexandria Women's Health Clinic, located on the second floor of the Landmark Towers condominium. It is the second busiest in the Commonwealth, responsible for performing 2,263 abortion procedures in 2016, over 13% of all the abortions in the entire Commonwealth according to the Virginia Department of Health, in their annual report, titled, Total Induced Terminations of Pregnancy Occurring in Virginia for 2016, VDH, 2016, and he was charged with the misdemeanor of trespass, codified as a crime by Virginia Code Section 18.2-119. Consistently and persistently from the day of arrest, Major Mike Webb has complained about violations of the First, Fourth, and Fifth Amendments in connection with his arrest, and has proffered corroborating evidence that has been ignored by the press, law enforcement, and the courts. In evidence, consequent to arrest, are confirmed incidents of destruction of personal property in custody of law enforcement, violations of Miranda rights through a contact, without the waiver of a right to an attorney or against self-incrimination, to Major Mike Webb by the arresting officers via telephone and email, illegal searches and seizures in a surveillance photograph taken by officers for the Alexandria Police Department during a court appearance, and extrajudicial contact and witness. Intimidation and obstruction of justice in the form of a social media gag order, and false publication, accusing Webb of spamming, as well as a telephonic issue of a telephonic protective order against him, with no magistrate authority, and which, despite a taped recording and confirming telephone records, the City of Alexandria Police Department deny. Just listen to the tape.
Mr. Webb, this is Officer Fontaine with the Alexandria City Police Department. I'm contacting you to let you know this person, Don Beyer and his family, does not want to be contacted or followed. Such continued contact will be prima facie evidence that you intend to place those people in reasonable fear in accordance with 18.2-60-3. However, you may continue in constitutionally protected actions such as legal process, as I understand you are pursuing, which is obviously your constitutional right. If you have any questions, you can contact the Alexandria Police Department. I'd be glad to talk to you and hear kind of what you have to say. Aside from that, like I said, continued contact while placing his family in reasonable fear, and I think you should understand that and respect that. You can reach me, if you'd like, at the Alexandria Police Department, which is 706-746-4444. Thank you. Bye-bye.
Additionally, despite receipt of an oral police report regarding electronic harassment by an anonymous troll, identifying himself as Stephen J. Miller, a pseudonym derived from the names of Father Stephen Imbarato and Monica Miller, the principal organizers of the Red Rose Rescues, the City of Alexandria Police Department, in an abuse of prosecutorial discretion, chose to classify persistent violations of 47 U.S.C. Section 223C as a mere annoyance, and failed to even open an investigation file or publish an official police report about a person attempting to intimidate Major Mike Webb, and prompting a report to Mayor Allison Silberberg and Attorney General Mark Herring regarding the illegal activity that both elected Democrat Party officials chose to ignore. Failures to prosecute this felonious actor resulted in redoubled efforts by the perpetrator, who began transmitting additional intimidating communications to a homeless litigant into the wee hours of the morning, during an unprecedented winter cold, immediately after Major Mike Webb's initial conviction, under the name Your Nemesis. Independent investigations performed by Major Mike Webb have confirmed that Stephen Miller and Your Nemesis are connected to another violator of 47 U.S.C. 223C, going under the pseudonym of Duffy Taylor, but whose AOL email account, lacking encryption capability, has been isolated to the Internet Protocol, IP, address of 173.73.156.240 in Arlington, Virginia, and associated with one Mary Miano, the former social media director of one Charles Hernick, the 2016 VA8 GOP congressional nominee, and whose email account, during a stream of hateful transmissions around Valentine's Day 2017 were tied to IP address 46.167.246.72, which is associated with criminal activity in Czechia. Independent investigative work performed by Webb also confirms that several individuals using the Arlington County GOP email address, info@arlingtongop.org and the Uniform Relocator Listing, URL, thisain'thell.us, are also connected to criminal activity in Czechia operating from their IP address. On February 9, 2018, despite the unlawful withholding of exonerating evidence, disclosable under the Brady Rule evidence, and releasable under the Commonwealth precedent established in Bustillo v. Johnson, Major Mike Webb was convicted and, over the recommendation of the Commonwealth for a $500 fine, expressly imposed for the inconvenience he had caused, the court handed down a suspended fine of just $300. In an attempt to control the aggressive trial strategy of an unrepresented litigant, the Commonwealth defied precedent, joining the co-participants in the Red Rose Rescue at the Alexandria Women's Health Clinic at the appellate level, rather than at the trial court level, arguing tradition and judicial economy, arguments the Commonwealth failed to raise in the separate trial court litigations of Major Mike Webb, Lauren Handy, case number GC 170045119-00, 1-year probation and $1,000 fine, withdrawn after agreement not to appeal, and Linda Mueller, case number GC 170045116-100, 1-year probation and $500 fine, withdrawn after agreement to withdraw appeal, Exhibit 18, in 5 months of litigation in the General District Court, and during which Major Mike Webb, despite being an unrepresented defendant, emerged from court with the least severe sentence. By letter, dated May 14, 2018, for the first time, the Commonwealth alerted Major Mike Webb to the existence of evidence that he would be permitted to examine but neither copy nor remove, and, in briefs, denied that it had any knowledge of the 3 subpoenas Dutses Tecum he had filed for service with the court and Sheriff's Department on May 1, 2014, and such sua sponte, of its own accord, with no request, disclosure, days before the scheduled trial on May 22, 2018, raised the first concerns as to whether the evidence to be reviewed was evidence releasable under the Brady Rule, articulated in the U.S. Supreme Court in Brady v. the State of Maryland, a 1963 case, because, in the Commonwealth of Virginia, a criminal defendant has no expressed right to evidence in the possession of law enforcement and the Commonwealth. Delivered via U.S. mail on Saturday, May 19, 2018, the letter only permitted Major Mike Webb the limited opportunity to view the evidence in the possession of the Commonwealth on Monday, May 22, 2018, the day before the scheduled jury trial, a circumstance that would have placed a seasoned attorney under great pressure, much less an unrepresented defendant, whose vulnerability a prosecutor is under an ethical obligation, under Professional Rules of Responsibility Rule 3.8 for the Virginia Bar Association, not to take unfair advantage. Yet, Major Mike Webb took full advantage of the opportunity to examine the evidence, in the exclusive control and custody of the Commonwealth, and took copious notes that have resulted in providing a basis for multiple pretrial motions, challenging both the prosecution and the arrest. But, most importantly, upon that first examination, Major Mike Webb discovered the existence of detailed surveillance video evidence in the possession of the Commonwealth on a shared drive that was not available at the time of his examination 1 day before the scheduled trial. With the adept skill of a seasoned litigator, Major Mike Webb asserted his rights and promptly moved for a continuance of the action to permit review of the surveillance video evidence, which was found to contain exonerating evidence that was withheld from disclosure, in violation of the rulings in Brady v. Maryland, 373 U.S. 83, 1963, and Bustillo v. Johnson, 63, Virginia Circuit Court Reporter 125, 2003, prompting a series of pretrial motions, later denied by the court's determination that the prejudice to trial rights introduced was not harmful error and an issue to be decided at trial. The scheduled jury trial of the joint defendants on July 5, 2018 was continued because of the unavailability of Officer Segura, witness for the prosecution, and his prior vacation plans. Private counsel for co-defendant Linda Mueller and the Commonwealth determined that the earliest possible date for trials that would not conflict with their vacation plans and personal reasons would not be possible until October 16, 2018. As an additional reason for delay of the trial, the Commonwealth asserted that repairs on the roof would make the courtrooms unavailable during the summer, but these repairs were never in evidence, nor provided any obstacle to the multiple pre-trial hearings on motions that Webb submitted from June to September. Moreover, engaging in an act of blatant willful blindness, on or about August 1, 2018, the Circuit Court, after several motions to introduce exonerating surveillance video evidence for review in camera, at the discretion of the court, the presiding judge interceded to change the scheduled courtroom from the audio-visual courtroom, equipped with the capability to review the material, to a courtroom where the video could not be viewed. Recognizing obvious prejudice in a malicious prosecution, on October 4, 2018, Major Mike Webb filed with the Federal District Court, and served to the Commonwealth, a petition for removal, on grounds of religious discrimination, a case initially assigned case number 1-18-00-1251, to which the Commonwealth has yet to reply. Upon following up with the federal court because he had heard no reply, and was unable to locate any information on PACER, the federal online portal for court cases, Major Mike Webb learned that the case was somehow accidentally assigned the wrong number, and one for a civil case, not a criminal one. The clerk of the federal court explained the error because of the fact that it was received by a new employee, who had no reason to know the proper procedures, especially since, in her 30 years of experience, she had seen maybe 50 cases of removal to federal court for discrimination, and none in recent years. Further, ironically, the original case number that was assigned to the case of Major Mike Webb has recently been assigned to a civil matter involving a condominium filing a warrant in debt against a former tenant alleged to owe assessment fees in arrears, just like the case to which Major Mike Webb had found himself subject almost 1 year ago, brought by his former condominium association, and brought on perjured affidavit swearing to the alleged fact that he was a resident of New Jersey, just weeks before the election for Arlington Public School Board, and the subject of current litigation in which Webb has claimed a tortious interference that the Arlington court has thus far denied as a valid claim, an issue now pending before the Supreme Court of Virginia. Moreover, Major Mike Webb only sought this extreme, and apparently rarely used remedy, because, at the end of July, Major Mike Webb had contacted the Attorney General Mark Herring for extraordinary relief in the subject litigation being prosecuted in the City of Alexandria Circuit Court and raised the serious constitutional violations at issue, but the Attorney General has yet to reply. Yet, somehow, ignoring the aggressive and contentious history of this case, the serious constitutional issues raised, and the service of a petition for removal, the Commonwealth proceeded to trial on October 16, 2018. Mona Parchaim, the assistant Commonwealth attorney assigned to the case, claims to have graciously waited for 45 minutes, ironically almost exactly the same length of time captured by the surveillance video that recorded the entry and extraction of the Red Rose rescuers at the Alexandria Women's Health Clinic, located in the Landmark Towers condominium, on December 2, 2017, before moving for a conviction exacting a fine, in absentia, for $300, plus court costs, under threat of driving license suspension, if not paid on or before November 15, 2018. It was these darkly disturbing details regarding a mere alleged trespass upon the property of an abortion facility, on the second floor of the Landmark Towers condominium, and asserted to be providing women choices and productive rights that were the result of an arrest that summoned every available unit in the Alexandria Police Department to respond within just 6 minutes, on the face not able to meet the threshold to warrant a call to the police under Commonwealth precedents for trespass. Articulated in Commonwealth v. Hall, 188 Virginia Reporter 72, 1948, and Pleasance v. Commonwealth, 214 Virginia Reporter 646, 1974. It was these darkly disturbing details regarding a mere alleged trespass upon the property of an abortion facility, on the second floor of the Landmark Towers condominium, and asserted to be providing women choices and productive rights that Major Mike Webb detailed in a motion to reopen the matter and provide a new trial for the crime for which he was convicted in absentia and with at least dubious evidence, to include not just what was at least inadmissible hearsay evidence from Catherine Orego Flans, the manager for the Alexandria Women's Health Clinic, but also obviously perjured evidence, a claim fully corroborated by the surveillance video that the court refused to view before the trial. And it was these darkly disturbing details regarding a mere alleged trespass upon the property of an abortion facility, on the second floor of the Landmark Towers condominium, and asserted to be providing women choices and productive rights, imaginable only in some dystopic vision depicted in a Kafkaesque novel or summer blockbuster film script that were presented to both Congressman Donald Byer and Senator Tim Kaine, who refused to even issue a reply while an apparently innocent man was convicted in absentia in a circuit court just around the corner from Congressman Byer's residence. Moreover, it was to these darkly disturbing events, detailed in a motion to reopen a criminal matter and provide an opportunity for a new trial that Mona Parchain, Assistant Commonwealth Attorney, a former public defender in Danville, Virginia and graduate of the law school at Wake Forest University, currently specializing in white-collar crime, examined and failed to issue a reply in a pleading. No. Rather, she swiftly docketed the motion for a hearing, unbeknownst to Major Mike Webb, and had it dismissed in his absence. Yet, in a land called America, and in a jurisdiction like Alexandria where Democrat politicians defy the authority of ICE officers seeking to enforce immigration laws against undocumented criminals, even in the absence of an advocate, what rational and ethical jurist who had read these facts in a brief would summarily dismiss and convict any man? A newly filed brief, filed with the Alexandria Circuit Court, in tandem with similar brief to the Federal District Court, where the petition for removal on the basis of discrimination, since October 4, 2018 remains without a decision, to vacate the conviction seeks to answer these darkly disturbing questions. And, already, Mona Parchain, the Assistant Commonwealth Attorney, has expressed her intentions not to cooperate with the resolution of the matter, refusing even to coordinate scheduling for the new hearing date. And, already, has the clerk's office for the city of Alexandria, that had back in May failed to even serve his subpoenas dutes tecum, indicated its unwillingness to cooperate, and, like the Federal District Court where the removal decision remains pending that somehow had assigned the wrong number to the removal action of Major Mike Webb, provided him the wrong hearing date when he attempted, in due diligence, to docket the matter with the court before the November 15, 2018 suspense for his payment of a fine. Can this happen in a land called America, a land that Governor Andrew Cuomo says was never great? Can this happen in the Commonwealth of Virginia, the great and old Dominion state that provided the words for almost every right reserved to citizens under the Bill of Rights and the oldest democratically elected legislature in the Western Hemisphere? Most importantly, can this happen in the only state in the former states of the Confederacy that voted for Hillary Rodham Clinton and against President Donald Trump in the 2016 elections? Can this happen in a congressional district where Don Byer, the champion for progressive causes, is the elected incumbent? Can this happen in a district where Democrat leaders claim to fight for the rights of dreamers and immigrants, who want to provide sanctuary cities and safe harbor for those seeking political asylum? Can this happen in a district where placards embrace the words that hate has no home here and that diversity is our strength? It is well established in the Commonwealth that in the rules of the Supreme Court of Virginia, in the section regarding criminal practice and procedure, the only sentence specifically addressing the presence of a criminal defendant is at Form 6. Waiver of Rights Form, Rule 3A8, question number 29, did you sign this plea agreement in the presence of your attorney? Moreover, Rule 3A2 states, these rules are intended to provide for the just determination of criminal proceedings. They shall be interpreted so as to promote uniformity and simplicity in procedure, fairness in administration, and the elimination of unjustifiable expense and delay. Errors, defects, irregularities, or variances that do not affect substantive rights shall not constitute reversible error. Under the rules of the Supreme Court of Virginia, criminal defendants are advised or specific trial rights to include self-incrimination, the right to confront and cross-examine witnesses, and the right to present a defense on their behalf, and, at the time of a voluntary waiver of these cherished trial rights, they are required to sign and acknowledge their deliberate choice to forfeit these trial rights guaranteed by the Constitution. Yet, under the Federal Rules of Criminal Procedure, it specifically states under Rule 4.3 that the defendant shall be present at the arraignment, at the time of the plea, at every stage of the trial including the impanelling of the jury and the return of the verdict, and at the imposition of sentence, except as otherwise provided by this rule, as noted in Crosby v. the United States, 506 U.S. 255, 1993. Yet, and still, in the Commonwealth, a Boolean query on Westlaw reveals that the instance of conviction in absentia has only been raised on appeal a mere 5 times, none for a misdemeanor nor a mere trespass, and all consistently establishing that a criminal defendant's absence from trial, conviction, and sentencing must be firmly established by a deliberate inquiry by the trial court to determine that the defendant's absence was truly voluntary, and not an act of prejudice by the prosecution or the court. Mindful that, under the Confrontation Clause, one of the most basic rights of an accused must be carefully safeguarded, the Court of Appeals for the Commonwealth noted that a presumption exists against the waiver of a constitutional right, and noted expressly and specifically, in determining whether there has been a voluntary waiver of the defendant's right to be present at trial, the implications which can be derived from a defendant's voluntary absence are fact-specific. Voluntary absence, standing alone, does not necessarily constitute a knowing and intelligent waiver. This was the rule articulated in Cruz v. the Commonwealth, 24 Virginia Appeals Reporter 454, 1997. While this reviewing court found that a defendant who had missed his trial date because of voluntary intoxication was insufficient to warrant a new trial, that court explained the precedents that guided that case-specific conclusion. And it noted that these 3 cases establish the rule that a knowing and voluntary waiver of the right to be present by a defendant who is voluntarily absent from the entire trial cannot be shown unless the defendant, 1. has been given notice of his trial date, and 2. has been warned that his failure to appear could result in a trial in his absence. In the present matter, it is clear that neither on the date of the trial, nor on the date of the hearing was Major Mike Webb, as in Cruz, voluntarily intoxicated, thereby voluntarily waiving his right to trial. In the present matter, as in Hunter v. the Commonwealth, 13 Virginia Appeals Reporter 187, 1991, it is clear that Major Mike Webb had knowledge of a trial date to be held on October 16, 2018 for his co-defendant Linda Mueller, a fact that had become known to him as moot only after the trial date when her counsel informed him that she had withdrawn. On October 4, 2018, Major Mike Webb had timely filed, and provided notice to the Commonwealth, a petition for removal with the federal court. In diligent exercise to protect his trial rights, threatened by clear evidence of discrimination from both the trying court and the prosecution, and, as the Court of Appeals held, distinctly absent was any evidence that the defendant had been warned he could be tried in his absence if he failed to appear. And, in comparison to the facts before the Court of Appeals in Head v. the Commonwealth, 3 Virginia Appeals Reporter 163, 1986, it is clear, here, that, despite allegedly waiting for 45 minutes fully aware of a filed petition for removal, there is no evidence that this, if his absence was justified, and it is clear that Major Mike Webb possessed and had articulated to both the trial court and the Commonwealth an explanation for the defendant's absence. And, as in Sist v. the Commonwealth, 3 Virginia Appeals Reporter 459, 1986, there is no evidence that the defendant had notice of the ultimate trial date or that he was warned that his failure to appear at any further stage would be deemed a waiver of his right to be present. For the above stated reasons, the verdict of the City of Alexandria Circuit Court, notwithstanding the dismissal of the motion to reopen the matter, should be vacated. Moreover, such conduct by the prosecution raises serious ethical issues under the rules of professional responsibility. Repeatedly, throughout this vexatious litigation, both the Commonwealth and the courts have been reminded, in pleadings, about the rules of professional responsibility that are endorsed by the Virginia Bar Association, particularly Rule 3.8, which provides: a lawyer engaged in a prosecutorial function shall A. Not file or maintain a charge that the prosecutor knows is not supported by probable cause. B. Not knowingly take advantage of an unrepresented defendant. C. Not instruct or encourage a person to withhold information from the defense after a party has been charged with an offense. D. Make timely disclosure to counsel for the defendant, or to the defendant if he has no counsel, of the existence of evidence which the prosecutor knows tends to negate the guilt of the accused, mitigate the degree of the offense, or reduce the punishment, except when disclosure is precluded or modified by order of a court, and e. not direct or encourage investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case to make an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6. Yet, the Commonwealth, since December 2, 2018, has maintained a charge that the prosecutor knows is not supported by probable cause, with the allowance of the court, in violation of Rule of Professional Responsibility 3.8a. A surveillance video, disclosable, mandatorily, under Brady v. Maryland, and releasable in replicate from under Bustillo v. Johnson, was not only withheld during the original conviction, but also only by initiative of an unrepresented defendant discovered and examined after he demanded a continuance when he learned of its existence 1 day before trial, when provided for examination by the Commonwealth. Both the police records and the surveillance video clearly impeach the Commonwealth's principal witness as a perjurer, establish that, even if her account were credible, that testimony could only be described as inadmissible hearsay, and demonstrate that there is no way that the requirements for even calling upon law enforcement to respond to a trespass in progress and subject anyone to arrest could not and did not occur in the 6 minutes captured on the video, and presenting, as to the Alexandria Women's Health Clinic, a cause of action in false imprisonment, as defined in Montgomery Ward & Co. v. Wickline, 188 Virginia Reporter 485, 1948, where it states that, false imprisonment is restraint of one's liberty without any sufficient legal excuse therefore by word or acts which he fears to disregard, and neither malice, ill will, nor the slightest wrongful intention is necessary to constitute the offense. The case also raises issues of malicious prosecution, as to the Alexandria Police Department and the Commonwealth, despite being generally disfavored under law, but malice may well be inferred from the want of probable cause. As noted in Wiggs v. Farmer, 205 Virginia Reporter 149, 1964. In the present case, even in this instance of conviction in absentia and denial of motion to reopen in absentia, has knowingly take advantage of an unrepresented defendant, in violation of Rule of Professional Responsibility 3.8b. In the present case, both the Commonwealth and the court, even resorting to willful blindness to prevent Brady Rule material from being examined, instruct or encourage a person to withhold information from the defense after a party has been charged with an offense, in violation of Rule of Professional Responsibility 3.8c. In the present case, and in those same instances, the Commonwealth, with the complicity and cooperation of the court, has failed to make timely disclosure to counsel for the defendant, or to the defendant if he has no counsel, of the existence of evidence which the prosecutor knows tends to negate the guilt of the accused, mitigate the degree of the offense, or reduce the punishment, except when disclosure is precluded or modified by order of a court, in violation of Rule of Professional Responsibility 3.8t. And, if anything more egregious might be imagined, in the present case, the Commonwealth, with the complicity and cooperation of not just the court, but also the Attorney General for the Commonwealth of Virginia, has failed in directing and discouraging investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case to make an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6, and in violation of Rule of Professional Responsibility 3.8e. For the above stated reasons, the verdict of the City of Alexandria Circuit Court, notwithstanding the dismissal of the motion to reopen the matter, should be vacated. To establish a case for malicious prosecution, a plaintiff is required to present credible evidence. 1. That the prosecution was terminated in a manner not unfavorable to the defendant. 2. That it was instituted or procured by the cooperation of the prosecution or law enforcement. 3. That it was without probable cause, and 4. That it was malicious, as noted in Bain v. Phillips, 217 Virginia Reporter 387, 1976. Legal malice, inferred from the circumstances, suffices for an award of compensatory damages, but actual malice must be shown to recover punitive damages, as noted in FBC Stores Incorporated v. Duncan, 214 Virginia Reporter 246, 1973, and quoted in Oxenham vs. Johnson, 241 Virginia Reporter 281, 1991. As noted above, and evidenced by both the conviction in the General District Court, the conviction in absentia in the Circuit Court and the denial of the motion to reopen in absentia, in pleadings, testimony, and presented evidence that argued a case based upon perjured evidence the court refused to examine, Major Mike Webb has sufficiently established, beyond a reasonable doubt, more than sufficient, that the prosecution was set on foot by a party and that it terminated in a manner not unfavorable to him or her. By the same evidence, Major Mike Webb has established, beyond a reasonable doubt, more than sufficient, that it was instituted or procured by the cooperation of that offending party. By the same evidence, Major Mike Webb has established, beyond a reasonable doubt, more than sufficient, that it was without probable cause. And, by the same evidence, beyond a reasonable doubt, more than sufficient, Major Mike Webb has established that it was malicious. Under the laws of the Commonwealth, as determined by the courts, if these elements are established, the court would have been justified in imposing a sanction. For the above stated reasons, the verdict of the City of Alexandria Circuit Court, notwithstanding the dismissal of the motion to reopen the matter, should be vacated, and sanctions, as this court may direct. But, today, this matter is for the courts of the Commonwealth to decide. And, today, equipped with this knowledge about a case in which both Senator Tim Kaine and Congressman Don Beyer not only possessed complete knowledge, but also permitted an American citizen to continue to fall victim to a grave injustice, you must in good conscience cast your vote on November 6th. Even if you cannot compel yourself to vote for a Republican, no moral person concerned with the Constitution and our American way of life can vote for Congressman Beyer or Senator Kaine. But, it's supposed to be a free country. It's your body and your choice.
This advertisement was authorized by Mike Webb.